Start. We shall first endeavour to address the submissions advanced at the hands of the learned counsel for the appellants with reference to section 15 of the Code of Civil Procedure. In terms of the mandate of section 15 of the Code of Civil Procedure, the initiation of action within the jurisdiction of Greater Mumbai had to be in the court of lowest grade competent to try it. We are, however, satisfied that within the area of jurisdiction of the principal district judge, Greater Mumbai only, the High Court of Bombay was exclusively the competent court under its ordinary original civil jurisdiction to adjudicate upon the matter. The above conclusion is imperative from the definition of the term court in section 2 within bracket 1 within bracket E of the Arbitration Act. Firstly, the very inclusion of the High Court in exercise of its ordinary original jurisdiction within the definition of the term court will be rendered nugatory. If the above conclusion was not to be accepted because the principal civil court of original jurisdiction in a district, namely the district judge concerned, being a court lower in grade than the High Court, the district judge concerned would always exclude the High Court from adjudicating upon the matter. The submissions advanced by the learned counsel for the appellant cannot therefore be accepted also to ensure the inclusion of the High Court in exercise of its ordinary original civil jurisdiction is given its due meaning. Accordingly, the principle enshrined in section 15 of the Code of Civil Procedure cannot be invoked while interpreting section 2 of the Arbitration Act. Secondly, the provisions of the Arbitration Act leave no room for any doubt that it is the superior most court exercising original civil jurisdiction which had been chosen to adjudicate disputes arising out of arbitration agreements, arbitral proceedings, and arbitral awards. Undoubtedly, a principal civil court of original jurisdiction in a district is the superior most court exercising original civil jurisdiction in the district over which its jurisdiction extends. It is clear that Section 2 of the Arbitration Act, having vested jurisdiction in the principal civil court of original jurisdiction in a district, did not rest the choice of jurisdiction on courts subordinate to that of the district judge. Likewise, the High Court, in exercise of its ordinary original jurisdiction, is the superior most court exercising original civil jurisdiction within the ambit of its original civil jurisdiction. On the same analogy and for the same reasons, the choice of jurisdiction will clearly fall in the realm of the High Court. Wherever a High Court exercises ordinary original civil jurisdiction under the Arbitration Act, therefore, the legislature has clearly expressed a legislative intent different from the one expressed in section 15 of the Code of Civil Procedure. The respondent had chosen to initiate proceedings within the area of Greater Mumbai. It could have done so only before the High Court of Bombay. There was no other court within the jurisdiction of Greater Mumbai where the respondents could have raised their challenge. Consequently, we have no hesitation in concluding that the respondent, by initiating proceedings under Section 34 of the Arbitration Act before the original site of the High Court of Bombay, had not violated the mandate of Section 2 of the Arbitration Act. Thus viewed, we find the submissions advanced at the hands of the learned counsel for the appellants by placing reliance on Section 15 of the Code of Civil